Well, thank you all for coming to this panel. This is historically always one of the most popular panels. The General Counsel panel, where we ask the chief lawyers from leading internet and digital media companies about best practices and how they develop those best practices. We have really an all-star group today representing the general counsels of Specific Media and MySpace, Twitter, Yahoo, eBay, LinkedIn, and Facebook. And it's going to be a very engaging discussion. We want it to be a discussion, so we want the audience to participate. If you have questions or comments, please, I guess the audio is on. If you have questions or comments, please jump in. And the GCs, to the extent they're able to, will also stay for the wine and cheese reception after, so we encourage you to do that as well. We're going to start with brief self-introductions for each of the panelists to just tell you who they are and a little bit about their legal department. Colin?
Thanks, Ian, and thanks for having us. I'm glad the U.S. soccer game finished in time to allow everyone to attend. So my name's Colin Stretch. I've been general counsel at Facebook since July of last year. I've been at the company for about 4.5 years. In my prior life, I was a partner at a law firm in D.C., a small firm there, focusing on regulatory and appellate and litigation work. Good enough?
Good enough.
All right.
Ditto, Colin, so thank you. Appreciate the opportunity to be here. I've general counsel of LinkedIn, and I've been at LinkedIn for about 6 years. And in my prior life, I started out as a special ed teacher, and some may ask what the differences are between the two, and there's a lot, but much of what we do is education. And I started my law firm career at Cooley, and this is the third general counsel job that I've had.
I'm Mike Jacobson, also known as Wile E. Coyote. I'm the general counsel of eBay and have been for almost 16 years now. Company's developed a little bit over that period. And before that, I was in private practice, and before that, I was in infants.
Hi, everyone. My name is Vijaya Gatti. I'm the general counsel of Twitter. I've been the general counsel for about 9 whole months now. So, and at the company for almost 3 years, and prior to that, I spent most of my career at a law firm here in Silicon Valley, Wilson Sonsini, practicing M&A and corporate securities law.
Hi, I'm Drew Bordash. I'm the general counsel of Specific Media, MySpace, and a company called Vendico. I've been general counsel for 3.5 years at the company, 3.5 years. Prior to that, I was in private practice doing primarily public and private company M&A at Gibson, Dunn & Crutcher down in Irvine.
And I'm Ron Bell. I'm the general counsel of Yahoo, and I've been GC there for about the past 2 years. But I've been at the company for almost 15 years, so quite a while. Prior to that, I was at Apple, where I was a transactional attorney, and before that, I was in private practice doing litigation and IP work in Chicago.
I'm still Mark Mumley.
So one question that's come up during the course of the day is how one determines what is a best practice. There obviously are practices that companies develop, but just because many people do something doesn't necessarily make it a best practice. Many years ago, we all remember backdating was a very common practice in Silicon Valley, but I think we would probably say that's not a best practice. And so from a practical perspective, from the perspective of a general counsel, how do you know what is a best practice as opposed to a bad practice? How do you develop practices, and what do you look to? Why don't we start at the end with Ron and go back in the opposite direction?
Okay, well, obviously, I would define a best practice as one that's reliable, consistent, and uses accepted metrics to yield a desired outcome, right? Maybe not the example of the backdating in that case. To me, the way we develop best practices is start with the problem in mind and the goal that we're trying to solve and work backwards from there. So there's a very different audience, I think, for different types of best practices, both internal and external. So we start with what the stakeholders are and what the goal is that we're trying to achieve. And then we'll look at what the tools are that we think we would need to deploy in that situation and try to build consensus. If there are people in the department that we need to involve or people external to the department, we'll get them together. We'll talk about whether we're trying to standardize or develop a different development methodology, whether we're really focused on doing some sort of assessment or tracking tool, and what the tools we have available are now. We look at cost reduction, efficiency gains, things like that. And then there's a bunch of external metrics we might look at, depending on if it's a legal department practice or just a general practice for the company in the legal area. If it's a legal department practice, we found the General Counsel Roundtable materials where they survey a number of different companies on their best practices to be very, very helpful, as well as the Association of Corporate Counsel material. But we'll get all the people together and we'll look at try to validate that it's a process that not only has been either employed elsewhere, but one that's appropriate to our culture and to the problem that we're trying to solve, and most of all, ensure that we have accountability, right? Who's specifically in charge and who needs to have the buy-in, and make sure that we have that before we roll it out. Because the best practice in the world out of a textbook doesn't work if you don't have the money to implement it, if you don't have the people that are going to pursue it, and if you don't have a buy-in from the stakeholders about what you're going to try to do.
So, we're probably, well, definitely the smallest company represented on the panel. So we also start with the problem, as Ron mentioned, but it's a little bit more fluid. We're smaller, more entrepreneurial, still founder-run, and it makes it a little bit more culturally challenging sometimes to implement best practices. So a lot of times it's trying to figure out a process that'll work for the organization and work for the speed of the organization that we like to move and our founders like to move. From my perspective, a lot of it is looking at other companies, including the companies on this panel, and also, a little bit of trial and error, frankly, on what we can do to streamline, improve efficiency, improve cost effectiveness, and also, a big challenge is always getting buy-in from my principals and sometimes other people in management, but I think primarily my principals, because sometimes, legal is perceived as more of a no function than a facilitative function, and so my job is to position to them why this is going to facilitate the business better than the way we're doing something currently.
Just to echo what both Drew and Ron said, I think one of the challenges that we always face is that our organizations are built to be very innovative, and we really push on the engineering and the product side, force everyone to be innovative, and I think that culture actually affects us as well. And so when we're coming up with best practices, one of the things, as Drew just mentioned, is finding something that actually works for the organization. And one of the things that never works for the organization is to tell them, this is how everyone else does it. So trying to find a solution that actually works for our company is as innovative as possible, given the constraints that we operate under. That's definitely one of the challenges. And for me, it's a lot about hiring the right people who are going to be asking those questions and willing to take those risks and push the boundaries when they're thinking about different practices that we're going to implement.
Best practices are sort of a combination of things. Obviously, it's somewhat industry dependent. It's somewhat size dependent. A lot of what we do as lawyers has to do with evaluating and figuring out how to get things down to appropriate risk tolerances. And what your risk tolerance is dependent on both what you need to do as a business and on things like your size. As you get larger, you can afford more risk, because if you're wrong, the likelihood that it kills your company goes down. Having said that, you cannot rely on what other people do as your guide, but it is useful to understand as a starting point, how do other organizations handle the same issue, and then you sort of have to do the the individualizing tweak for your particular situation. As a very large company with a large legal department, we have the advantage of having in-house a lot of different perspectives from different companies, and that's certainly one of the places we start.
Yeah. So we all deal with innovative companies and where the companies are moving really fast. This is the internet, right? And we deal with uncharted waters. And so what we've said is there may not be a right answer, but there is a right process. And what we do is try to identify the question. We then look to see who else has had a similar issue. Rarely will you find the same issue. And so we'll benchmark that. Then we'll call a couple of really trusted advisors. They may not even be specialists in that area, but just people who you just trust and they share similar values. Could be internal, could be external. And then we take a look at all of that, the gestalt of it, and then we apply the LinkedIn way. And the LinkedIn way goes to what the values are, the socialization. Obviously, you need to know what you want the desired outcome to be. But again, may not be, it's important to identify the question, benchmark it, trusted advisors, and then the LinkedIn way. And at the end of the day, you implement and you go back and do exactly what your product guys and your engineering gals do, which is iterate, figure out, post-mortem it, iterate, and make it better.
I don't think I have much to add. I mean, I think what we're hearing, and it sounds right to me, it certainly sounds consistent with my experience, is that you can rely on external sources, either other companies or advisors, to help generate ideas, but nothing's going to work unless it works for your company. And each of these companies is structured in its own unique way with different organizations doing different functions with different personalities involved. And I think that's the hard part. Whether any of the practices we've employed are best yet, I have no idea. But that's where the fairly consistent review matters, and it's where the fact that the companies themselves tend to evolve quickly helps, right? Because, if the process you put in place isn't working yet, maybe it'll work, maybe the business will grow into it, or the business will take a left turn and you'll have to be coming up with something new anyway.
So one challenge,
there's a lot of that.
Trust your gut.
There's a lot of that. That is true.
So one challenge in developing best practices is how companies should develop practices to operate internationally, because there are many areas of internet law where U.S. law differs from the law in Europe or Asia or other countries. We've seen that as a thread through many of the panels today. Erica, what are your thoughts on best practices for U.S. companies dealing internationally? What are some of the things that in-house lawyers should look to?
I think it's really the same in terms of what you've just heard here. Obviously, we need to be aware of what the laws are in the major jurisdictions in which you're operating. The internet makes it hard because there's 200 countries, over 200 countries and territories around the world, and oftentimes there's conflicting regulations or conflicting laws in country by country, and in some countries like Germany, the states within the country don't agree. It's not so different than here in the United States. And so to the extent that you can be aware of what the laws are, be aware of it. We certainly believe that one should be proactive with regulators and law enforcement and other stakeholders around the world, and the no surprise rule. But it really goes back to, I think, the same themes that you heard earlier in terms of best practices.
What about other thoughts and ways to deal internationally?
I think there are a couple things you need to be thinking about as you deal internationally. One is that, generally speaking, in the United States, if there's a law on the books, there's likely to be someone who's going to be willing to enforce it, and you got to pay attention to it. That's not the case in many other jurisdictions, and so you need to find someone who can help you navigate not just what the laws are, but as written, but also what the laws are as applied. And you have to be pretty clear if you're dealing with outside counsel as to whether you want a true whether you want a true picture of what the laws really are, or whether you want a particular result, because in many cases they will assume the latter unless you tell them the former. Having said that, though, in the end, the processes are pretty similar.
So one international law that I know several of the panelists felt was a concern was this whole notion of information that disappears, the European right to be forgotten, which is a principle that in some ways conflicts with U.S. First Amendment principles, or California's online erasure law set to take effect next year, which many people also think may have some legal problems. From a practical standpoint, we're dealing with something that is very important based on the cultural values of a different legal system, but conflicts with the U.S. legal system. What are your thoughts on the ways to address those kind of problems? Erica?
Me? That's going to be the next general counsel's. Yeah, I actually think that where the whole right to be forgotten and, as Billy Hawkes will say, the fundamental right to privacy, which we also do have in the United States, but there's also a fundamental freedom of expression. I think that we're headed on a collision course, and something's going to have to happen to try to reconcile opposing laws or conflicting laws around the world. Because the internet is global, and I don't think that we've ever had such a global being in the past, and traditional notions of forum and jurisdiction just don't work or aren't going to work. And I think we're starting to see, we're beyond the beginning stage or the infancy stage. I don't think we've gone to the end result yet. I would suggest that in Europe, I think that folks will, and I don't mean to be presumptuous here or offensive, but with this decision, should there be an issue of public interest that is, that's erased in essence, and you can look at some countries that engage in, and I don't mean to suggest that the European decision equals what I'm going to talk about, but in certain countries where there's a lot of censorship, and general populace doesn't necessarily know about major things that have happened in their country. I just think that we're headed to a head, and we haven't sorted it out yet. And I don't know what the answers are on this. I mean, it's really hard. And do you end up with a global court? But on the other hand, even in the EU, you've got the conflict with the lead data controller. And so just think about, and that's within the EU that already has a set of common principles and guidelines and regulation. How do you expand that to the world? But I think it's going to be a really, really interesting issue over the next decade. So I'm not answering the question and I'm rambling, but it's a tough one.
Yeah, you've done it very, very well, though, in terms of circling around.
Can I take your job for a second, Ian, and ask a follow-up? I think the interesting thing for me is, as Erica says, there's going to have to be at some point some sort of cooperation amongst international jurisdictions, but the fact of the matter is, even within the United States, we can't get cooperation on sort of what our frameworks are in certain respects. So my question, I guess, to the panel is, what role do companies have to play in the meantime, whether it's threatening to pull out of jurisdictions, actually pulling out of jurisdictions, refusing to just to abide by certain laws on principle? What role do sort of the major big businesses that can probably affect things in the short term, what role do they play?
So, I think it's an interesting and provocative question. I think Erica has rightly identified some significant and very hard questions sort of down the road. I think if we, roll it back a little bit, what does Europe do now with this right to be forgotten? And even that is a challenging question, because it is, I think, even within Europe, a controversial proposition, and it's not as though it's perceived to be an absolute right. There are other fundamental rights. There's a fundamental right in Europe to run a business, and that's one we like to sort of try to enable. How do you balance those two fundamental rights? I don't know. The question I think that that Drew is sort of teeing up is, how can we drive that? How can we drive some resolution and find some balance? I think, one, I think practical outcome of this decision is, I think it potentially puts even more attention on the data protection regulation that has been considered in Europe and is likely to continue to be considered. I think, candidly, I think for a lot of American companies that do business in Europe, it may change the calculus of how they approach that. For the most part, most companies have been, kind of trying to put the brakes on that, on the theory that any regulation is bad, and we're doing okay under the current regime. I think some companies are going to need to revisit that. Not sure if Facebook's one of those yet. We're still trying to figure that out, but the fact of the matter is, certainly for Google, and Kent's not here, so he can't disagree with me, but that I think that puts a fairly significant operational burden on them. It sort of changes the jurisdictional math for companies that haven't voluntarily acceded to jurisdiction in any particular EU country. That, to me, suggests that some companies, Google among them, I don't know, may engage more aggressively with respect to the legislative process in the EU, leading to potentially a more sort of rational, thoughtful, hopefully, outcome. I mean, to me, there is a window to try to address some of these things. Where that'll land, I don't know, but I think we'll see a pretty active conversation around that.
To what extent are your companies using geolocation to respond to the issues Drew was raising, so that it's, rather than trying to move the law in the various countries, just sort of fragmenting the site and serving different content to different people in different countries?
The problem is it doesn't work because people can always go to your site in a different country, and because so many, it is still relatively rare to have a company with a lot of country-specific sites. The courts in Europe, and I have personal experience, essentially have said, it really doesn't matter to me that you have a wonderful .fr site. We still view your .com site as being in effect locally, being in effect local. And as long as that's the case, there's not a whole lot of upside to spending a lot of money to individualize particular sites and say only you can see this. Now, you do it if you have to, if you're faced with an injunction or something like that, but it's a lot of work, and it's not clear that it will get you the results that you want.
I agree with that. I mean, jurisdictional issues aside, I think, the value proposition of what we're trying to offer would be so impaired by the segmentation that it begs the question of, like, can we even offer it in that way?
It's also hard. I don't know if this is on. It's also hard to know exactly how to implement, because the decision didn't really provide guidance in that way. It said, that European citizens have a right to remove things that they consider irrelevant or no longer relevant or overbroad, but not a lot of guidance to us on how exactly to accomplish that, how to validate who they are, how to make sure that the content that they're removing is not of historical relevance, it's not of legal relevance, potentially. A child molester, for example, who wants to remove something that's, a conviction or a link to a site that contains content other than the article just about that individual. So I think there's a lot of open questions, and I think, coming back full circle, Colin, to where you started, Wes, I think a lot of the goal here is really for us to think about, look, how do we be good citizens of the world and try to implement this decision in the EU in a way that makes sense and be thoughtful, and then engage in a dialogue with the regulators about the problems and if necessary with the courts, about the problems we're seeing and the challenges we're facing in actually implementing a system. I think it's going to be challenging, though, in the absence of some guidance, to figure out and have consistency among companies about how we're approaching this particular right. But we're certainly committed at Yahoo to trying to figure it out. for ourselves.
And Drew, I just want to go back to your question in terms of what role do companies play, and do you pull out of countries? How do you engage? I think that's a really good question, and I think that as companies, and Ron, as you said, we do need to be good corporate citizens, and I would suggest that each of you really think about what are your first principles as a company. Are there certain lines that you just won't cross? Have you discussed that, as a legal team? Have you discussed it as a leadership team? And to stay true to those. And it doesn't mean that you won't at some point cross that line, but at least be intelligent about it. I think it is important for us as companies to, I think that we sit in a very interesting, and we all sit in a very interesting role because the internet's here to stay. That cat's out of the bag. And so how do we, and balkanization of the internet, even if certain countries really, really wanted to do it, it's just not going to work because you can access a .com site from wherever you are. And I do think that there needs to be a lot of dialogue by the leading internet companies. I mean, we're here in the Valley where the innovation and the smart minds and put it together, 1 + 1 = 3. I think that as a government, that the US government needs to be involved in. I think that we need to be having a global dialogue about how do we resolve this because putting up walls isn't going to work.
Should we transition to intellectual property? All right. So in 1989, before any of the companies here were founded, intellectual property in the computer world looked like strong copyright protection, strong look and feel protection, and protection for functional aspects, and virtually no patent protection. You could, it turns out, get software patents, but only if you pretended they weren't software patents, and only if they were tied to a specific machine. I could patent a pizza oven that had computer technology that controlled it, but not general technology. By the early 1990s, both of those trends had reversed. We cut back rather substantially on copyright protection, both by introducing rights of reverse engineering, rights for compatibility, and in the Lotus versus Borland case by limiting the copyright protection for functional software. At about the same time, we greatly expanded software patent protection and made it generally available. 2014 might well be the year we go back to the future. And specifically back to 1989. In the Oracle versus Google case, the Federal Circuit seems to have brought back strong copyright protection for application programming interfaces, disagreeing with the Lotus versus Borland decision and suggesting there may be strong copyright protection. At the same time, we're poised to perhaps see a significant step backwards in time with respect to software patents as the Supreme Court decides the Alice versus CLS Bank case in the next 2 weeks. And I guess the question for the panel is, what would that world look like for you? How does your interaction with intellectual property differ if we back off of software patents and move back towards a world in which copyright plays a more significant role?
Our CFOs would be happy.
Yeah, that's a good world.
Okay, and why is that? Money? Do we spend less money?
Spend much less money, right? The cost of patent litigation is huge. I mean, it would be interesting to know what the troll cost is for each of our companies. I mean, and my guess is that the vast majority of the patent cases, from a litigation perspective, that each of us face is troll litigation. Where you really don't have any leverage at all. And then also on the side of patent prosecution. I mean, it's huge.
I agree. I mean, I think many of us have been railing against the problem of troll litigation for years. It doesn't show significant signs of abating. I mean, I think we've gotten some decent decisions around the edges and are getting better at dealing with it, but it is just a drag. I mean, I don't mean like a drag, but it's an economic, it's both a drag and it's a drag. So
with no upside. With no
right.
upside.
Right. And so I think that's a to me, sort of anything we can do to limit that problem in a relatively targeted way is great. And there was legislation that that made it out of the House last year and died in the Senate that seems to have been a relatively targeted effort to address some of that problem. That to me would have been a good thing. And maybe in the next Congress we'll get another crack at it. But I don't, honestly on the Oracle decision, I just don't know what that's going to look like. I think we were sort of chatting about it a little bit earlier. It does feel like there's some tension there between that decision and the Lotus Borland case and some Ninth Circuit case. Whether we're going to see more, whether the Supreme Court's going to look at it, or whether the Federal Circuit will look at it again. I don't know. I don't know what seems like there's a lot of litigation around fair use that'll happen even if the decision remains intact. So I just don't know exactly what that's going to look like. So I guess bottom line, I would say good limiting software patents, unclear putting some new teeth into copyright as a means to protect intellectual property in this area.
What about pro bono issues? I know that that's of concern to many companies. Colin, what's your perspective of an internet company's best practice with respect to pro bono?
So I don't think it's unique to internet companies in this way. At least so it's a great question. It's a really important question. It's something we've been working hard on, and I confess without as much success as I would like. I think in-house companies have traditionally not done a great job, or in-house legal departments have not done a great job of providing opportunities for folks to fulfill their pro bono responsibilities. We're experimenting with a whole range of different things. We've been working with San Mateo Legal Aid, and we've been working with Community Legal Services of East Palo Alto. The single best thing we've done to create opportunities is partner with law firms which have institutional structures set up, and they make it unbelievably easy to provide opportunities. The hard part, candidly, on our end is getting people excited about it. I think in law firms, it's a slightly easier sell, potentially because it gives folks an opportunity to maybe get trial experience that perhaps they're not going to get in the early years of their law firm journey. And there's other sort of hourly credit that you can provide. I think we're still searching for the right formula to make sure that people are excited about it, giving them good opportunities. I think there's more work to be done, but there are partners out there to help provide really good opportunities.
We have actually a very active pro bono program that we started about a year and a half ago. We've done in the past year over 19 different projects. And it started from the grassroots, actually. People came to me and said, we'd like to do some pro bono, would you support it? And I found that if I just said yes and actually showed up myself and made it something that was a priority for the department, said that we're going to make giving back to the communities in which we work globally one of our big projects for the year, that there was a lot of excitement about it. And then it's become sort of self-perpetuating. I mean, this year we're on track right now to do over 20 projects, which is pretty exciting. And as Colin said, I think there's a lot of infrastructure there to, with the law firms and with the legal aid associations for people who are interested in getting started with a program like that. For us, really the key, though, was starting from the grassroots. We have an entire committee. We call it the People Committee. It sounds very Maoist, I know. But they oversee things like our mentoring program, our recruiting and retention, our development of attorneys, our community service. And it all starts from the ground up. And then people develop the programs, they'll bring them to me, and I'll obviously go through them, and we'll talk about what makes sense and over what time frame. But I just find that once you empower people and make it okay to do those things and say this is part of what we do as a company, what we do as a department and a community, that people step up and amaze you and surprise you and do things that I would never have thought of. So we've been very pleased with how it's been going so far.
Yeah, I think that pro bono service is really, really important. And when you're in-house, there's no question that it's much harder to do because we don't have the infrastructure. The law firms have been incredibly helpful. And if you're a law firm lawyer, if you're looking to do business development, ask your clients, hey, can we help you do a pro bono project? It's incredible in terms of the team building that occurs between the law and the relationships that are built between the law firms and the in-house lawyers. It's an incredible opportunity if you're in-house, just in terms of team building for your own team. We are so blessed and fortunate to be in this valley and to have the ability, and I guess just the riches that we have and what we take for granted. And you may think that, okay, you're in-house, you don't necessarily have a special skill, or like I do contracts, or I litigate, what am I really going to do? And I don't have the time. The projects that we've done have been single-day projects because we recognize that our folks don't really have the time. We want to make it super easy. There's all sorts of projects that are out there that you can do. You can, as Colin said, whether it's a San Mateo Legal Aid, whether it's the Silicon Valley Law Foundation, whether it's the San Francisco Bar Foundation, whether it's One Justice, I mean, truly, like, the opportunities are limitless, and I would encourage you to just talk with each other, talk to us about it, because the opportunities are there. And for your lawyers, or for yourself, just the opportunity to, like, help someone is incredible. We did a DACA project. It was a deferred action project, and helped folks fill out forms. You may say, well, and our guy said this, like, we don't know anything about immigration law. How are we going to do this? And it was just amazing. It was one of the most magical days of my 6 years at LinkedIn. It was really incredible.
Well, another issue that folks have been grappling with in-house is balancing the privacy rights of members against national security concerns. Mr. Snowden's trip to Russia last year surfaced a lot of information, and for many internet companies created a lot of business and ethical issues. Erica, why don't you tee up the issue? I know many people on the panel have views on that, but what are best practices for balancing in this new world, the privacy rights of members against national security concerns?
Yeah, I think that this issue has existed for a long, long time. And for anyone that knows about ECPA, the Electronic Communications Privacy Act, if this is my Rolodex of contacts, the U.S. government needs to have a search warrant. If, however, my list of contacts is stored in the cloud, the U.S. government believes that it only needs a subpoena to access those contacts. And there's no reason why our Fourth Amendment rights should vary based on the manner in which our contacts are stored. And so this issue really has existed for a long time. And at LinkedIn, our core value is that our members come first. And we don't want to pit member privacy versus the government or security concerns, but there's a process in the United States that the government should follow, and the Fourth Amendment trumps various other laws, and what you got to do in terms of best practices is, again, go back to what first principles are. We operate in uncharted territories, uncharted waters, and the laws that exist on the books, as Mike said, may not be it's a real law, but technology has advanced and is advancing, and you have to take a look at what should the law be in the context of where we are today and what the technology is today. And as Drew said, you also have to be willing to push that envelope and to challenge it. And thankfully, we live in the United States, and we do have the ability to challenge it. And yeah, we do have values as companies. From the global perspective, that clearly makes it much, much harder. And it goes back to the question that you had in terms of how do you operate in the international regime? And the answers are the same. You've got to navigate that.
I think one of the things here is obviously transparency. And I encourage you all to look at the companies up here and the transparency reports, because one of the problems here is there is very little transparency about about what the national security interests are that we're competing against, and it puts us as companies in a very difficult position when trying to evaluate that, and even trying to be transparent to our users about what actually is going on and under what circumstances their information is being requested and by whom and for what purpose. So I definitely think that that's one area where Twitter is continuing to be focused, is the ability to be more transparent to our users about what the requests are and when they're coming in.
Just by a show of hands, who's opposed to national security? No one.
And who supports national security and our government's obligation?
Everyone. And so the question isn't really whether you're opposed to national security. The question is whether you're in favor of restrictions on how governments can get data that are reasonable, well-documented, consistently followed, and subject to a degree of oversight that makes sense considering what's involved. Transparency is part of it, but you have to have strong checks and balances, and that's why many of us, are co-signatories on reformgovernmentsurveillance.com, which you can go see, which talks about basic principles that we're pushing for globally that we think make sense in this context. You really can't have a situation where freedom is served up a la carte, right? You have to have principles that make sense. They have to be principles you've thought through, and then you have to implement them and push for them to be implemented in ways that make sense, recognizing that there are national security concerns, but also making sure that the interest of the user are first, and that's where we come at it. That's the perspective that we're taking. In the international setting, stepping beyond into a much broader context, we think that companies have a role at the table in setting the dialogue, establishing the principles, and also thinking about, as they're designing their products, the human rights implications of what they're doing, whether they're designing products in a way that make it easy for governments to subpoena data, or more difficult, whether they're locating their servers offshore or not, what processes they have in place for addressing those issues. We have an entire business and human rights program at Yahoo, which is a bit unusual, of full-time people who do nothing but not only reach out and educate themselves about issues in other countries and reach out to NGOs and governments and understand their perspectives on issues, but also come back and help us influence our product design process and make sure that our employees understand how important these issues are. Because when you really get down to it, what we're trying to do is make sure that our users are protected and that we're protecting fundamental human rights in a way that is intelligent and thoughtful and consistent, and that is internalized not just by the legal department, but by every employee, so that we create systems people can rely on.
I think I'd add one point. I think for me anyway, the most sort of practical, tactical outcome of these disclosures over the last year has been the urgency to protect our networks from a technological perspective. So I think, one of the transparency point that Vijaya emphasizes is critical, and all of the companies have obtained the right to release some information, not certainly enough, but some. And I think if you do read the transparency reports, I think you come away with the recognition that the volume of access obtained by the United States government under its national security related authorities is not that extreme, and it doesn't shock you. What I found shocking, and what I think a lot of folks found shocking, is the fact that in addition there were, or at least the allegation that in addition there were efforts to gain unauthorized access to either to data centers generally, or to individual targets not using lawful process overseas without our visibility, and that was, I think, felt like a betrayal to most of the companies that have worked very hard to be responsible corporate citizens here. we've always tried very hard to protect our networks. We thought we were protecting our networks from bad actors. Now that we know we're up against an entity with much more resources, we need to redouble our efforts. And that's what we're doing, and that's what most companies are doing, and that's fine. And that's sort of our responsibility to ensure that one of the principles that Ron mentioned is honored, which is that access to user information should come through lawful process. And that's a pretty simple proposition. I think everybody can get behind it. Certainly we're all behind it. The other thing to keep in mind, though, is that this is a global challenge, and there are plenty of government entities beyond the United States that seek access to information on people, often for what I think most of us would think of as inappropriate ends. And that's one of the, this sort of comes back to the point that Erica was making earlier. Like, what are some of these common standards? What are some of these principles that the industry is going to live by going forward? Because there is not uniformity in terms of the appropriate type of access or the appropriate type of data requests. I think in many countries around the world, we certainly get our share of data requests that purport to be national security related and are plainly speech related cases. And we are successful to date in pushing back. But it is simply not the case that there's a norm out there that law enforcement around the globe only seeks access when it's real crime or real terrorism. It's a challenging issue. It's a particularly challenging issue internationally.
Ian, you were asking, and we were discussing best practices earlier, and the Reform Government Surveillance Coalition that came together, I think, is just a gold standard for a best practice and was really, really effective back in Washington, D.C. The companies spoke with one voice. The companies were respected. In D.C., it was an issue that President Obama clearly was engaged with, as a constitutional lawyer, was deeply bothered by what occurred, wanted to hear from companies here. And what at least I had heard, and I think many of us heard, is that our talking amongst ourselves when the news broke and realizing that we needed to do something and as an industry and coming together and, again, speaking with one voice was incredibly effective and can be a model for issues in the future. And just from a very practical perspective, again, uncharted waters, reach out to your colleagues at other companies. I know for many of us, it's been that communication and picking up the phone. I remember talking with Ron over the weekend, in fact, about it. I mean, it's just, what do you do? Because you don't necessarily know, because there isn't a roadmap of folks who've come before you.
Colin suggested the problem is not just a United States problem, and I think that raises a broader question of, we talked earlier about international jurisdiction and conflicting laws, but I guess I want to ask the specific question of how you deal with autocratic regimes, how you deal with governments that have imposed very substantial restrictions on freedom. Mike, do you want to take a shot at that?
Sure. It's challenging. Start there. And sometimes you do find yourself, when you are in a country, particularly when you're in a country with people, you can't simply say, I disagree with your political system, so I'm going to ignore your laws. That is a recipe for disaster on all kinds of different levels. So you are frequently find yourself being very measured in how you respond to what on their face appear to be somewhat conflicting sets of rules, all of which you have to meet with. And you literally have to feel your way through and hope that the conflict does not become so direct that you end up having to abandon either one country or the other. Sanctions are an easy example. The fact of the matter is that sometimes in adhering to, let's say, U.S. sanctions, you may be violating the terms of a license in a particular country, and you just have to sort of sort through that and figure out what is the least dangerous way to do that. But there are, quite frankly, lots of cases that don't necessarily involve, autocratic governments. There's a German law which forbids companies in Germany from adhering to the Cuban boycott regulations passed by FinCEN and OFAC. That's a bit of a problem. We've been enjoined a couple of times as a result of that. And again, you just have to, you will always find yourself in circumstances where you simply cannot do exactly what the law appears to literally require, and then you have to figure out your least bad alternative and move forward from there.
I think I've spoken a little bit about this before, but autocratic regimes generally don't suddenly become so overnight, right? So you have a chance on the front end to think a little bit about whether you're going to go in the first place, and if so, what you're going to do there. And I think one of the most important things you can do is create a culture in your company and educate your executives and your board about what you think your responsibilities and your principles are going to be when you go into some of these places. That means thinking about product design. It means thinking about where you're going to put your people on the ground who might be vulnerable if one of these issues comes up. It means having formal systems and processes to protect data and information and making sure that the people who are responsible for implementing them understand what they are. And it means having a legal team, and I think this is true of everybody up here, who's willing to back people when they do have to stand up for a user's rights, or they do feel that they need to stand up for a principle, and making sure that people not only know that we will back them, but seeing that we will, in fact, do so and go to the mat for them. The other side of it, of course, is being open and transparent with governments about how our products work, what we do, why we're there, what the principles are that we operate with, and with our users about the requests that we may see. As Mike said, it's really hard to be a citizen of the world because there's so many different laws. Some of them we agree with, some of them we don't agree with. But for us, we find that if we stick to some pretty simple core principles of human rights, that the answers, or at least a direction in how to handle most problems and handle them consistency, really does emerge. And so, we're very focused on making sure that our employees internalize and understand the responsibilities that we feel as a company in how we're rolling out our products and how we're engaging with governments and with our users.
I think, similarly, the autocratic governments are sometimes easier to deal with in that sense because you can rely a little bit on your values and your philosophy, and you can make some judgments about whether you want to be there or not be there, and what risks you're willing to take. The challenging situation for us was most recently in Turkey, where we were blocked over what we felt was political speech, and what we felt very strongly was freedom of expression, which was a recognized concept in Turkey. And working through that situation in a very tense environment of an election, reaching out to government officials and being very calm, reaching out to our colleagues at YouTube who were undergoing a similar situation. But I feel like myself, I learned a lot through that process of how to keep cool, because it feels like this very crazy thing that you have to get turned back on before the election, otherwise what's the point? And but governments work at their own pace, and educating them and working with them it's often working under their laws. You know, I could go in there all day long and tell them, you have this enshrined concept of freedom of expression, that's what this is. They're not going to believe me, but when their constitutional court rules and says, yes, this is about freedom of expression, and you work within their boundaries, you're much more likely to get a favorable result. So it was definitely a challenging, intense situation, but I think one that you know, if people are able to like be calm and approach it as rationally as possible, you can find a way through it.
And you find that what you think you know sometimes, you know, that you take for granted isn't actually something you can take for granted. I'll give you an example. We did a program a couple of weeks ago where we invited literally activists from different countries out to share their perspectives, to tell us what they would like to see in our products and things that concern them, things that are working well. And one of the things that someone said, I won't mention the country, but it qualifies as an autocratic regime, was two-factor authentication, which we use here in the United States, basically having a telephone where you can, you know, if someone accesses your account, you'll get a pager, or you'll have to enter in a number that you get sent as an SMS. That, you know, we look at that as an account recovery and protection tool that we think is a best practice, be rapidly becoming a best practice. Sorry about, oh, that's mine. And his point was, yeah, but when you do that, you're SMSing me. And if I've given you a valid phone number, you're telling the government I'm associated with that account, and they have access to those phone records. So that's something, you know, that wouldn't be in my daily experience, isn't something I'm necessarily thinking of, but reaching out and getting perspectives and as Vijaya said, educating yourself and educating your employees about what some of these issues are really helps you to think about them in a new way.
We want to open the floor to questions. There are two fundamental questions that the panel wanted to address, but we do really want to get questions. So as we go through these last two issues, you know, please consider lining up at the microphone so we can get the questions recorded and think of the questions you want to ask. One of the two things we wanted to follow up was what's the best practice in building a legal department in this kind of changing environment and scaling that legal department? Colin, what are your thoughts?
I think we've actually been thinking about this a lot lately. I guess the attribute that I think is probably most prized inside versus outside counsel is, and this is going to sound offensive to the people who are at law firms, and I apologize in advance. I was there for 10 years. But I do think there's a real premium on interpersonal skills in-house, not to say that they're not important at law firms. But I think, you know, one of the biggest challenges we have is to communicate in what typically is a fairly nuanced area in a crisp and actionable way to people who don't really have the time or patience or really even the need to understand the nuance. And that's hard. That's just hard to do. It's hard to get it at the right level. And it's not something that necessarily correlates with, you know, where you went to law school or what your substantive area of expertise is. But it is absolutely critical to having, in my view, in my judgment, to having an effective in-house department. So that's, I think there's a real premium there. In terms of hiring, in terms of scaling the operation, I don't know, you should probably talk to somebody who's actually built a bigger one. We're still about 90 people.
Not me then.
It's got to be Mike.
Well, scaling is actually pretty easy if you hire the right people at the beginning and let them do all the work, because they do it far better than you can. I mean, you know, the reality is that one of the great features, one of the great attributes of working in-house is you really get to understand a business, and you really get to on really a daily basis apply your legal knowledge to a particular set of business facts and in an effort to solve a particular problem. And you do that to some extent, obviously, in every legal situation, but the reality is typically in a law firm, you're not going to be able to get the deep knowledge of what the business is and what it's trying to do and where it's going and what are the true things that are important to it as opposed to the things that you might from the outside appear important to it. So when you start by hiring people who have a commitment to, doing that and understand what that looks like and what the kinds of people who are going to be able to do that down the road look like, and then you sort of set them loose to find through sometimes their networks, sometimes the more traditional recruiting process, a group of people that are going to be really good at it and really want to do it. And it obviously helps if you're in a successful company that continues to grow relatively quickly, like folks on my left. You can scale very successfully. At some point, you actually have to put some organization in place, and that's sort of the second element of scaling. It turns out that the particulars of the organization are not that critical. My organization doesn't actually make any sense, but it's sort of grown over time, and we make it successful. But you do need to sort of make sure that as you scale, internal communication stays fluid and continuous, and that you have the right goals in place. And as long as you can do that, you'll be able to continue to grow until you're as large as Kent Walker's organization.
Drew, what are your thoughts?
Well, I guess from our perspective, I was the first in-house lawyer at Specific Media, and so I probably look at it a little bit differently, just stepping back fundamentally from sort of like, do we have the budget to hire somebody? So making the case that, there's always greater efficiency, I think, having somebody in-house versus outside, because of a lot of things Mike mentioned, which is the deep integration into the business, the deep knowledge that you gain in the business. But there's, start with justifying, okay, why do I need this headcount? And then what is the, the need that I have? And, primarily for me, I've hired generalists, and what I look for is people who are, have, good pedigree, good interpersonal skills, clearly, a level of intelligence that allows them to come in and attack different areas, because one day they might be dealing with a labor and employment issue, one day they might be dealing with a privacy issue, one day they might be dealing with a thorny commercial contract. So, I think that the number one thing I look for is somebody who I believe has sort of the natural abilities, somebody who can think very practically, and somebody who's able to sort of take something and run with it, where I don't have, I don't think any of us have a lot of bandwidth to be micromanaging. So it's very important, I think, to get somebody who can think for themselves, who's very practical, and that can take a project and run with it all the way through. And then as I've grown the department now, you get to a place where I have to decide whether there are certain specialties. Do we have enough labor and employment work? Do we have enough privacy work? And then, I think, yes, certainly we have enough privacy work. And then it's, okay, how do I look at the organization and the resources that we have and where we're investing in the business and make a case that, this is much better brought in-house versus, continue to do it sort of ourselves, where you're not going to have the same level of expertise, although we follow it closely, you're never going to have the same level of expertise. And then rely on outside counsel for that extra, 40, 50%, 30%, 10%, whatever it is. So those are the challenges that I've personally faced, and the way I look at kind of scaling on a small scale so far.
So I wanted to ask each of you to just in a few words, where do you see internet law going? From your company's perspective, what are the big trends, either positive or negative, that you see? If you could look in a crystal ball and we come back for the 14th or 15th annual e-commerce best practices conference, what are the trends that you see? And we'll start at this end with Colin and go through the list.
So this will be a very pessimistic view. I don't see this actually happening, but I can tell you what I'm really worried about. I'm really worried about a world in which the internet is regulated according to standards that we don't think of as consistent with the tenets that we all studied in law school, right? So freedom of speech being the main one, and some degree of protection from unwarranted government intrusion. I think those are two areas that are not, they're certainly not always respected in the U.S., but they're respected here more than they are respected in most other countries. And I worry that internet governance will evolve in a way that is less respective of free speech and less protective of freedoms from unwarranted government intrusion.
So Colin, I don't disagree with you, and I think that we're going to face those issues, and I think that we're probably in for some hard times, but I actually do believe that around the world that freedom of expression will prevail, and maybe that's an ethnocentric view, but when you spend, I think that there are governments that don't have, we know that there are governments that don't have the same fundamental belief in freedom of expression, but I think when you get down to the citizen level, by and large, from a Gestalt perspective, that freedom of expression will prevail. And I think we're in for some tough times, but I think that the internet is here to stay. I think that the internet will change the world, and I think that the internet will be a driving force in the promotion and creation and advancement of emerging democracies.
I have a slightly different concern coming from probably the same place, which is, I certainly hope it doesn't happen, the balkanization of the internet. And we've already seen, and I think we're going to continue to see, a lot of at least discussion and possibly actual laws passed in various jurisdictions requiring effectively that the internet, if you want to reach people in that jurisdiction, has to be local. You can't just sit in the United States relatively safe and pump your internet out into the world. There'll be a Russian internet, there'll be a Brazilian internet, there'll be a Indian internet. And I think that if that happens, a lot of the positive things that the internet have brought over the last 20 years, roughly, will start being lost. But there are certainly straws in the wind that suggest that may be a direction that we're going to see, and then we're going to have to figure out, as lawyers, how the heck do we deal with it?
Yeah, I agree. I worry about the same thing, and certainly as a product that tries to be one thing for all people around the world, I worry about how we can do that if you have different laws in every single country that apply to what's going on.
Drew, give us some optimism, man.
Yeah, I was going to say, you guys are so optimistic. I'm hopeful that the internet is so powerful that it can overcome certainly a full sort of balkanization of the internet. I think there are going to be pockets of problems globally in the bigger sort of autocratic states. Another area where I think is going to be interesting to see how it develops is the continuation of just proliferation of data in the cloud, and both the responsibility for companies sitting up here and other companies to protect that data and use it consistent with user expectations is a huge challenge. There's no black and white law. I think we will probably see data security law, maybe not pre-election, almost certainly not pre-election, but maybe post the midterm election, depending on how quickly the campaign season for the presidential election kicks off. I don't think we're close to comprehensive privacy legislation in the U.S. I don't think we're close to harmonized privacy legislation in the EU, although they've got a standard. It's implemented differently across the different EU member states. And, there's a lot of ad hoc privacy laws around the world in a lot of states that aren't really focused on it at all. So for me, one of the most interesting things to sort of watch, and I don't know how it shakes out, is as more data moves into online, what does that mean? I think it creates enormous opportunity for personalization and customization and revenue opportunities for all kinds of businesses. But I also think that it creates a lot of challenges, some of which we've already talked about around, first of all, state access to data, personal, hackers, access to data, and so don't know where we end up, but it's certainly a big challenge I see going forward.
I'll just add on to the end of it. This is pretty amazing. I'm not talking about the iPhone. I'm talking about just the concept of the iPhone and the device. When I was in college, we had to actually go to a library and go to books to find out information. If you lost track of someone that you spent time with in college, you could never find them again. You had to buy maps. This is crazy. The internet has already changed everything, but as all of this information and more comes online, we're seeing some trends in the other direction, right? People are starting to say, what does all this information mean, and how should we think about it? And not just how should we regulate it, but how should we treat it from a product perspective? How should we think about it as companies? What are the rules of engagement? I see a couple of themes, and some of them have come out of our discussion here today. Individual rights versus state rights to access to information, privacy rights versus rights to know or freedom of expression, right? Access to information, something we didn't talk about, net neutrality, right? Who is going to control the pipes, and under what circumstances and under what terms? All of these are really going to be topics that I think are going to be subject not just of a national dialogue, which obviously is happening here in the U.S., but of a continuing global dialogue and normalization. And we'll see, as countries and companies feel their way through this, a lot of variances in how this is all going down. But I think, in the end, these are the right dialogues and conversations to be having. There's always two perspectives, but it's the right time to be having these conversations. And so I think all of us are committed, I hope all of us are committed to being a part of those dialogues and informing them and trying to drive them in a way that makes sense and balances the many interests that are at stake. The one thing I would add to what's been said, a topic that didn't come up, which isn't so much about internet law, but about the internet industry, it's kind of interesting. Up here today, all of us are companies headquartered in the U.S. I think in 5 years, it will be hard to have a conversation about the internet industry where that's the case. So I think we're definitely seeing some trends, and we'll see some new ideas coming in the other way too, and new perspectives, and that will shape the dialogue as well. But I think it's an exciting time to be in internet law. I think it's an exciting time to be at an internet company, and frankly, I think it's a pretty exciting time to be alive. Pretty amazing. Thanks.
Well, it's really hard to top these comments, so why don't we, this is probably an appropriate time to go to the wine and cheese reception to continue the dialogue, but perhaps with a glass of wine in your hands. Thank you all for coming, and please give us your evaluations